This is an appeal in the matter of the Commissioner of HMRC.
Mr. Watkinson.
May it please your Lordships, I appear on this appeal for the Appellant, His Majesty's Revenue and Customs, with Miss Brown. My learned friend, Mr. Brown, no relation, appears with the learned friend, Mr. Morris. As my Lords will know, there is a third-party intervenor, Dual Fuel Nutrition Limited, which has been permitted to intervene by written submissions only on the direction of my Lord Justice Lewison. And my Lords have those submissions in the core bundle at page 49.
Yes.
But at the heart of this appeal, despite the context being Mega Marshmallows, is we submit the proper interpretation of and approach to the legislation in Schedule 8 of Part 2, Group 1 of the Value Added Tax Act 1994, or VATA for short, which determines whether a food product is zero rated for VAT or standard rated as confectionery. The particular focus, my Lords, is of course on Note 5 to those provisions. The correct approach to that has been the subject of apparent dispute between various constitutions of the Upper Tribunal, and what the correct approach is will have a wider significance, we submit, for products beyond this case that may fall within them. My Lords are probably familiar with the type of product itself. If not, we do have photographs in the bundle that I can take my Lords to. So on this appeal, my Lords, we make three overarching submissions. And whilst I make the first, can I invite my Lords to turn up Authorities Bundle, page 32. It's tab 6 in the first volume, and it is Note 5 itself. Our first overarching submission, my Lords, is that the tail piece to Note 5 is an inclusive definition that significantly and deliberately enlarges what is included within the term confectionery for VAT purposes, and the Upper Tribunal erred in finding otherwise. With both the respondent, in my learned friend's skeleton argument at paragraph 22, and the intervenor, in their submissions at paragraph 8, disagree, and they submit and argue that the tailpiece is clarificatory only. So whilst...
When you say tailpiece, can you just
forgive me, my
clarify
Lord,
exactly which words you're referring to?
and any item of sweetened prepared food which is normally eaten with the fingers is what I'll refer to as tailpiece, which I should have made clear.
Thank you.
So whilst the appellant accepts that the Upper Tribunal was correct that that tailpiece is not an automatic deeming provision, we do submit that the Upper Tribunal went too far the other way. We submit that it's an enlarging, inclusive definition, and on its face before my Lords, its words are clear and unambiguous. And they are, read normally, a very deliberate, we submit, and significant enlargement of what is included within the term confectionery. as part of our broad submission, we will submit that the legislative history of the provision also shows that the amendment to Note 5 to include this tailpiece was just that deliberate and significant enlargement. By way of a trailer to that, can I ask my lords to turn up page 8 of the authorities bundle, please, at tab 3. Which is the immediate predecessor legislation in item 2 of Group 1, Schedule 5 to VATA 1983. My lords will see there item 2 is previous Justem generis broadly type drafting in the form chocolate, sweet and similar confectionery. And as we will go on to submit, one can trace that formulation all the way from the Purchase Tax Act 1963 through to the original enactment of VATA in 1983, but it was then abandoned in favour of the current legislative formulation. So we broadly submit, my lords, that simply carrying out the exercise of comparison reveals that Note 5 has the enlarging effect for which we contend. As part of the consideration of the legislative provisions, there are 2 we will submit admissible extrinsic aids to which will take the court. That we submit also support that submission. Those are the explanatory note to the 1988 order that amended VATA and a statement to Parliament. We will also submit, my lords, that under that broad submission, that it's no surprise that such an inclusive definition should have the enlarging effect that we contend for, since that is the general reason for using such definitions. So whilst the tailpiece to Note 5 may not amount to the creation of a statutory hypothesis, as one may see in a true deeming provision, we do submit that the effect of the tailpiece is to bring within it products that otherwise would not have fallen within the term confectionery. And we further submit that the practical difference between a true deeming provision and an enlarging inclusive definition, which enables a term in the Act to be applied to something which it would not ordinarily apply to, is not a great distinction. And we submit that there are similar checks on those 2 formulae, whether they're an inclusive definition or a true deeming provision, in terms of ensuring that the interpretation does not produce an absurd or unjust result. So we submit that the Upper Tribunal erred in concluding that the tailpiece to Note 5 did not have an enlarging effect and was clarificatory only, and we will submit that that error is also reflected in the Upper Tribunal's reasoning, which we will seek to unpack. Our second overarching submission, my lords, concerns how Note 5 is best applied when a tribunal is considering any given product. We will submit that in a case where Note 5 is engaged, once a tribunal has made the relevant findings of fact and concluded that the product under consideration falls within its clear and unambiguous wording, subject to considerations of absurdity or a lack of reality, for example, that the product is demonstrably well outside of what Parliament intended the legislation to cover, such as the sweet chili chicken skewer example that my lords will have seen in the skeleton argument of one of the authorities. Subject to that kind of consideration, the product is confectionery for the purposes of Note 5 and Item 2. And we submit that the Upper Tribunal erred in concluding otherwise. As part of our broad second submission, my lords, we will rely on three general propositions. Firstly, whether a particular interpretation of a statutory provision produces what can broadly be termed an absurd result is a perfectly legitimate tool of interpretation. Secondly, my lords, in the context of tax legislation, the ultimate question is often whether a particular transaction falls within a given statutory description on a realistic view. And thirdly, my lords, we submit that there is a parallel in the limits on interpreting true deeming provisions, in that such provisions should not be applied to produce unjust, absurd, or anomalous results, unless the court is compelled to do so by clear language. Instead of treating Note 5 as a statutory inclusive definition, we submit that the UT instead described it as akin to a rebuttable presumption, which could be displaced by an apparently untrammelled multifactorial assessment or value judgment. We will submit that that approach pays insufficient regard to the definition enacted by Parliament, and that rather than providing at least some principled line that the tribunals and parties can use in any given case near the borders, the UT's approach tends more towards incoherence, unpredictability, and subjectivity. Our third overarching submission, my lords, is ground 2. That concerns how the Upper Tribunal dealt with the case, having concluded that the FTT erred in law but saying they hadn't done so materially. And our submission will be that having found that error, because the FTT did not apply Note 5 to the product before it, the UT should have concluded that that was a material error of law and it needed to be remitted to make the relevant factual findings, and it was an error not to do so. So, my lords, we propose to group the remainder of our submissions under the following heads. Firstly, the legislative history of the provisions. Secondly, the general approach to statutory interpretation. Thirdly, the specific aspects that arise in this case, inclusive definitions, interpretation of domestic VAT exemptions, and the always speaking principle. Fourthly, how the tax tribunals have previously approached the legislation. Fifthly, the instant UT's approach. Sixth, what we submit are the Upper Tribunal's errors of law. And finally, some submissions on the respondents and intervenors' arguments. If I might move to my submissions on the legislative history of the provisions, my Lord. In our submission, it is helpful and indeed necessary in this case to follow that legislative history. And we submit that the tailpiece to Note 5 is best understood against the background of the previous law. Firstly, the legislative history is part of Note 5's context. It assists with a purposive interpretation. Secondly, they assist in identifying the mischief at which Note 5 was aimed. And thirdly, the history assists in showing the prior legislative approach that was set aside, we submit. We've set out the relevant history as was considered by the Upper Tribunal in our skeleton at 12 to 17. I begin with the Purchase Tax Act 1963, please. My Lords have that at tab 1, page 5 of the authorities bundle. In essence, the structure of that act was that staple foods were not subjected to the tax, whereas items considered to be luxuries were. The Group 34 that my Lords have there, taxed goods comprising chocolate, sweets and similar confectionery, etc. So that's the phrase that we will see reoccurring. One then goes on to page 6 of the same bundle, please, my Lords. That's Schedule 4, Group 1 of the Finance Act 1972. As my Lords will see, that preserved the general status quo at item 2.
Just to be clear, when it says glace...
glacé, it should be glacé, my Lord. I think it's
glacé.
It's not picked up the
acute accent.
No. So that then employed the same statutory phraseology. One then moves on to VATA 1983, which my Lords have at page 8, to which I've taken you.
This time it hasn't got an accent at all, or inverted commas.
No.
Do we know whether the original has an accent, or don't we know?
For my part, I don't. My presumption, if I'm asked for it, would be that it did, but that it's not been picked up in the scanning. But I don't understand there to be any dispute. It's glacé or crystallised fruits to which that part applies. So, my Lord, that's VATA 1983, the same phraseology employed at item 2 and over the page at page 9. You have note 5, which simply at that point read items 2 and 3. So those are the drained cherries and candied peels of the items overriding the exceptions relate to item 2. The next step then, my Lords, is tab 7, page 33, please. The Value-Added Tax Confectionery Order 1988, statutory instrument number 507 of that year. That's substituting for the legislation we've just looked at. Item 2 then becomes that formulation, and then note 5 is amended by addition to the end. So the phrase "and similar confectionery" goes, chocolates and sweets are moved into Note 5. And we also have the addition of what we've referred to as the tailpiece. There's an explanatory note to that order, my lords, which is in the second volume of the authorities bundle. Tab 34, very last page, page 561. There is the slightly Rumsfeldian formulation of certain uncertainties being removed, but after that the intent is recorded as being to restrict the scope of the relief for other confectionery products, etc. The main immediate effect will be to tax all cereal bars at the standard rate. In our submission, that is setting out that the intent is to restrict the scope for relief, general zero rate of food, so that products which hitherto might not have been treated as confectionery are thus restricting the scope of the food relief. And we submit that the restriction of that relief could only realistically be achieved by enlarging the definition of confectionery. So more products would then fall within it. Whilst the main effect, my lords, is said to be main immediate effect is said to be to tax all cereal bars, the legislative change we submit plainly went well beyond that, and the note itself does not suggest that the effects were confined to such products. My lords also have, in volume 2 of the authorities bundle, tab 29, page 528, a statement to Parliament by the Chancellor of the Exchequer in the budget statement on the 15th of March 1998. My learned friend, I understand, suggests that it might not be admissible. We submit it is admissible to supply context or identify the mischief at which the legislation is aimed. So we're not in pepper and heart territory.
Does it add anything of any importance?
The only addition we rely on, my lord, is the recording of the obsolescence of the definition. In somewhat ungentlemanly terms.
That presumably was the joke.
Yes. One would hope so, my lord. We do rely on the notion that the definition had become outdated and outmoded, and that was part of the driver of the legislative change. Other than that, nothing more. If there's a doubt as to admissibility, we have the section of Benyon 2412 at page 559 of the second authorities bundle, tab 33. I don't think my learned friend's taking the point, he informs me, but for completeness, my lords, page 559. It's the proposition we rely on.
So just be clear, which bit?
It's simply the section.
Context, to supply context to identify the mischief.
Yes, at which legislation is aimed. That's the only part.
So identifying the mischief. Which bit identifies the mischief? The bit about cereal bars, recent decisions meaning that some cereal bars are subject to VAT while others aren't.
But the primary identification of the mischief we submit is the emergence of new products has rendered the definition somewhat obsolete. So the mischief is products being interpreted as not falling within the legislation.
So the mischief is to catch new products.
To ensure that the definition can cater for emerging or new products rather than them being interpreted as falling without it. The instant concern there being that there had been decisions that cereal bars were not confectionery, but there being a reference to other new products as well. My Lords then have the current legislation in the first authorities bundle, tab 6, page 30. So under item 1, my Lords, food used of a kind used for human consumption is 0 rated. But there are then the accepted items beneath that. So under item 2, confectionery, save for the specified carve-outs for cakes, biscuits, etc., none of which apply here, is accepted from that 0 rating. And then, my Lords, one has note 5 at page 32.
Can I ask the same question? Is there a word glacé? Or is that glacé again?
It should be a word glacé, my Lord, not glass egg. I'm not aware that there's such a word at all.
Yeah.
The final part of the current legislation, then, my Lords, is section 96(9), which is at page 26 of the same bundle. Tab 5. That being the interpretation clause, broadly speaking.
So what we're told is that Schedule 8 is to be interpreted in accordance with Note 5.
Yes. So, having been through the legislative history, my Lords, we do submit that it supports the proposition that the tailpiece to Note 5 was a deliberate and significant enlargement of what is included within the term confectionery. The previous eustem generis type drafting in the form and similar confectionery was deliberately abandoned. The reason for that was perceived obsolescence of the definition and the need to restrict the scope of food relief. And the way in which that was achieved was, we submit, by enlarging the term. I move on to my second head of submissions then, please, my lords, the correct approach to statutory interpretation. I invite my lords to turn up, please, in the second volume of the Authorities, tab 24, at page 391, please. We've summarised the principles from the authority in our skeleton at 29, but just to take my lords to it. Judgment of Lady Justice Asplin, with whom my Lord Justice Lewison and Lord Justice Arnold agreed in PSV 1982 Limited in Langdon. And there are three particular points that we seek to rely on. Firstly, the primary source by which the meaning of legislation is to be ascertained and the limit on extrinsic aids. Secondly, the role of absurdity. And thirdly, in construing tax legislation, the ultimate question often being whether the statutory provisions construed purposively were intended to apply to the specific transaction viewed realistically. So at page 391, my lords, Her Ladyship cites the Supreme Court in the Crown on the application of the project for the registration of children as British citizens, the judgment of Lord Hodge. We rely in particular on what's cited at F, the words which Parliament has chosen to enact. It's an expression of the purpose of the legislation and therefore the primary source by which meaning is ascertained for the important constitutional reason that's stated. And then at G, citing paragraph 30, that external aids must therefore play a secondary role. At J, none of the external aids can displace the meanings conveyed by the words of a statute that, after consideration of that context, are clear and unambiguous, and which do not produce absurdity. Over the page at 392, please, my lords, paragraphs 28 and 29 refer to avoiding absurd results, and we'll come on to Project Blue. And then 29 citing Rossendale and Hurstwood on the purposive approach that I'll also come on to. Can I take my lords briefly to Project Blue, please, which is in the First Authorities bundle, tab 20, page 293. Paragraph 31, please. Project Blue being an SDLT case about the Chelsea Barracks and subsale relief. But the point we rely on at paragraph 31, Lord Hodge saying that it's without question a legitimate method of purposive statutory construction that one should seek to avoid absurd or unlikely results. As to the meaning of absurdity, can I ask my lords to turn up page 241 of the First Authorities bundle, tab 19, please. judgment of Lord Kerr in the Supreme Court in McCool, endorsing passages from Bennion. This is at paragraphs 24 to 25. We rely on those two paragraphs, my lords, for the proposition that absurd has a wide meaning, including results which are unworkable, impracticable, inconvenient, anomalous, etc. As to the ultimate question in construing tax legislation, can I ask my lords to go to tab 23, please? That's the first authority in the second volume. Page 361, please. This is Rossendale and Hurstwood, dealing with the Ramsey principle in the context of schemes to avoid non-domestic rates. Firstly, at 10, citing Quintervol, on the need to read controversial provisions in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. The exercise we've just done, my lord. Over the page then, please, at 362, paragraph 13 at the bottom, please. Referring to the House of Lords' decision in the Barclays-Mercantile case, as making it clear beyond dispute that the approach for which the Ramsey line of cases is authority is an application of general principles of statutory interpretation. And then over the page at the top, please, Lord Nichols quoting from Arrowtown. The ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. So we submit that this authority is good for the proposition that the history of the provisions, part of its context, which we've dealt with. Secondly, we rely on it for the proposition that interpreting tax legislation, the ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. And we apply that in this context, not to a transaction per se, albeit of course a supply is a transaction, but nonetheless we seek to apply that same approach. And we submit that when one looks at how a product answers the statutory descriptors in Note 5, how a court is meant to deal with that, we submit that if a product answers one of the statutory descriptions, then one applies an unrealistic or absurdity check, and if the product doesn't fail that check, then confectionery it is. I move on, please, to my third heading, specific aspects of interpretation that arise in this case. So firstly, inclusive definitions. Take my lords, please, to second volume of the authorities bundle, tab 31, page 555. There, my lords, have the extract from Bennion, section 18.3. Firstly, at 1, an inclusive definition modifies the natural meaning of the defined term by enlarging it or clarifying potential doubt about what is covered.
I'm sorry, which page are you on?
Forgive me, my lord, this is page 555, tab 31 in the second authority.
Yep, thank you.
And at 3, what inclusive and exclusive definitions have in common is that they specify matters that are or are not to be treated as caught by the defined term, but otherwise leave the natural meaning of the term intact. In the comment, an inclusive definition is used to enlarge the meaning of the defined term to cover things that are not or might not be otherwise caught. Does not normally affect the width of the term being enlarged. The term as used in the Act has its natural meaning, which is left undefined, and in addition has the special meaning given to it by the inclusive definition. At the bottom of that page, Bennion cites Lord Watson in Dilworth, that I'll take my lords to. Thereafter, Lord Selborne, the Chancellor in Robinson and Local Board of Barton Eccles, to the same effect. Particularly the last part of that, that it enables the word as used in the Act to be applied to some things to which it would not ordinarily be applicable. And then there's an example in Thomas and Marshall that I'll also take the court to. So can I take my lords to Dilworth then, please, which is in the first volume of the authorities, tab 10. Page 84, please. Dilworth, my lords, is a Privy Council case that considered Section 2 of the Charitable Gifts Duties Exemption Act 1883. At the bottom of page 84, my lords, have the relevant section, Section 2, that includes the inclusive definition. Charitable purposes includes devices, etc. And then over the page at the top is Section 3 containing the exemption. Bottom of page 85, Lord Watson's observation on interpretation clauses such as that. 3 lines up from the bottom. The word include is very generally used in interpretation clauses in order to enlarge the meaning of words or phrases occurring in the body of the statute. And when it is so used, these words or phrases must be construed as comprehending not only such things as they signify according to their natural import, but also those things which the interpretation clause declares that they shall include. So, my lords, we rely on Bennion and Dilworth for the following 2 propositions. Firstly, where the word includes is used in an interpretation clause, that's generally done in order to enlarge the meaning of a word occurring in the body of the statute. Secondly, my lords, where it is so used, the word to which it applies must be construed, covering not only those things within the natural meaning of the word, but also those things which the interpretation clause declares that they shall include, which would not ordinarily be included in the natural meaning of the word. The next authority then, my lords, please, is at tab 13 of the first authority bundle, Page 140, please. This is Thomas and Marshall. In that case, the House of Lords considered the definition of settlement in Section 21 of the Finance Act 1936, which bore on whether interest in accounts in the names of the appellant's children should be treated as his income. Right at the bottom of page 140, my Lords, is the relevant inclusive provision, Section 21(9)(b). The expression settlement includes any disposition, etc. On page 141, then, at the top of the second sidelining, the only point for determination was whether the absolute gifts in question were settlements within the meaning of Section 21. And Lord Morton then said thereafter he too would answer the question in the affirmative. It's true that an absolute gift of money or of an investment would not ordinarily be described as a settlement, but it is expressly enacted that in Section 21 the expression settlement includes inter alia, etc. My Lords then go over the page. Lord Morton then considered the decision in Yates and Starkey, noting the observations of Lord Justice Jenkins. Who had said, I must go to the definitions provided by subsection 9, construe those definitions and apply them according to their true construction, however remote from the ordinary conceptions of settlement or settlor the content of the definitions may in any given instance appear to be. And the next paragraph records the appellant there seeking to argue that a transfer of assets didn't come within Section 21 unless it was in the nature of a settlement itself, and that is what was rejected at the bottom of page 142 as being, and over the page as being a subversive suggestion as to the meaning and operation of such an interpretation clause. Third line down, the object of the subsection is surely to make it plain that in Section 21 the word settlement is to be enlarged to include other transactions which would not be regarded as settlements within the meaning which that word ordinarily bears. The next paragraph, His Lordship finds that there's no context effectively to displace that. So, my Lords, we rely on Thomas and the extract from it cited in Bennion as an example in support of our proposition as to how inclusive definitions generally work, and that is why we submit that there is no surprise that an inclusive definition such as that in the tailpiece to Note 5 should have the enlarging effect we contend for. Based on Bennion, the trio of cases that we rely on, that is generally what such definitions are used for. My Lord, I move on to interpretation of domestic VAT exemptions and the always speaking principle that the respondent relies on, please. The zero rating for food with which we're concerned, my Lords, is a domestic exception to chargeability to VAT under the EU standstill provision. It's not a harmonised VAT exemption. The Upper Tribunal summarised the position on that at paragraphs 8 to 9 of its decision correctly. For my Lord's note, it's also explained in the Supreme Court's judgment in News Corp and HMRC. Might I just give my Lords the reference to that?
Yes.
That's Second Authorities Bundle, tab 25, pages 411 to 414, paragraphs 14 to 23. That's the operation of the standstill itself. If I ask my Lords to go to the part of the authority dealing with interpretation of domestic exemptions, please. That's tab 25, page 419. Paragraph 38. Please. The judgment of Lords Hamblin and Burrows, with whom Lords Hodge and Kitchen agreed. Plainly, it's in the context of newspapers, but it applies as much to the food exemption.
So just to be clear, if this is in play here, you might expect the word confectionery absent note 5 to be construed narrowly.
You expect food to be construed narrowly. You expect a provision taking.
Oh, sorry, yes. Food,
out,
confectionery
other way
would
round.
be construed widely.
Yes. So.
Or at any rate, not narrowly.
Exactly, my lord.
And then you say, on that basis, note 5 is, if anything, construed generously.
You say.
I'm getting it the wrong way round now.
No, you say note 5 is effectively construed generously, so you're not seeking to apply a strict interpretation because it brings something back into the charge to tax. As soon as you construe it strictly, it has the effect of expanding the scope of the food relief itself, which is what can't be done under the standstill. So one derives that from paragraphs 38 and 39 on strict interpretation, particularly 39 in a case where it involves standstill provision exemptions. The Supreme Court set out the always speaking principle, just for my Lord's note, unless I'm asked to go to it, that's paragraphs 28 to 30.
How does the always speaking principle affect the question here?
I think, as I understand it, my Lord, the respondent relies on the always speaking principle to say that that is in some way an answer to how the statutory provisions ought to be interpreted. And our submission is the only way that the always speaking principle operates is actually through the tailpiece. So through the tailpiece, note 5 is always speaking to whatever new products might come onto the market, whether they existed in 1972 or not. That's how we submit that the always speaking principle works. What we do submit, though, is it can't be used to somehow cut down tailpiece or any part of note 5 or cause a strict interpretation of note 5 or the tailpiece. That's the conflict that arose for dispute in News Court.
Well, I understand it in News Court because they were dealing with the VAT treatment of some technologically innovative product, electronic newspapers, which did not exist when the exemption was first written. But I don't understand how that translates. I mean, it's not suggested that marshmallows are some 21st century invention, is it?
No, my lord. It's simply that the statute will always be speaking, but it's doing so in the context of a VAT exemption and an exception to that exemption, and whether one can rely on the always speaking principle to somehow narrow the definition of confectionery, which I think is what my learned friend said.
But the words in the tailpiece are all perfectly ordinary words that haven't changed their meaning or application. Sweetened, prepared, fingers.
Precisely, my lord. That's my point. It's in.
So at the moment, well, I'll wait to see how it's put. At the moment, I don't see that the always speaking principle has any part to play in this particular question at all. But maybe I've misunderstood.
Well, no, our submission, to be clear, my lord, is that the always speaking principle only operates here in the ordinary way, which is the statute is always speaking, but the way in which it does it is best through note 5's tailpiece, because that is apt to cover.
But is always speaking relevant at all unless there is some new product or new circumstance which the principal needs to take into account.
No, it's not normally relevant, my lord. So it's not like one goes back to the embryo cases and the classic cases of always speaking as to whether something needs to be modified so that a cat includes a dog and those kind of analyses. So we do submit that the always speaking principle will have a role, as with any statute, but it doesn't achieve anything in particular in this case.
Can I ask you another question? You said that Note 5 should be construed generously as it brings something back into charge. Now, I understand entirely the submission that it is the exemptions, zero-rated bits of the statute, which have to be construed strictly. But does it follow that something like Note 5, which takes a food out of the exemption and into taxability, has to be given an unusually generous interpretation? Or
No, my
just, so
no.
Can I replace the word construed generously with construed normally?
Yes.
Yes. Thank you.
Yes, I think generously might have come from the bench and I adopted it.
Yes.
And I shouldn't have.
Yes.
There's no requirement to interpret Note 5 strictly. It can be interpreted normally. My lord's quite right. So, my lord, those are really the submissions on the always speaking principle. We submit it doesn't take the respondent any further in this case, not least because of the context in which the court's being asked to apply it.
And I think you're really saying that the need to construe exemptions narrowly doesn't take one any further either.
It only takes one further in that food has to be interpreted strictly, so one needs to be careful not to bring more into that than is already catered for within an exception.
But we're not actually dealing with the definition of food here, no one disputes.
No, not
Mega
dealing with the definition of
marshmallows
food, my lord, of course, but you are dealing with an exception that would bring something back into food as zero rated, as opposed to standard rated confectionery.
But I think you accepted a moment ago that that doesn't mean you construe Note 5 generously.
I do.
Yep.
So, my lords, might I move to the fourth heading of my submissions, which is how previous tax tribunals have approached the legislation. And of course, none of this is submitted to be binding, but we do submit that the court might be assisted by seeing how the provisions have been applied, in fact, for products that might be near the borderline, and whether that approach is correct or whether the Upper Tribunal's approach is correct. But there's no dispute as to the general approach to VAT classification, so Pringles, potato-y type goods, etc., which is multifactorial analysis. Slightly different question we submit to Note 5. We've provided two examples in the skeleton, my lords, to illustrate the approach of the First Tier Tribunal. Firstly, please, the last authority in the first volume of authorities, tab 22, page 327. This is Corte Delito from 2020. My lords, go to page 328, paragraph 1, please. That sets out the product being considered. Newey truffles, subsequently called Newey healthy balls. They're described at paragraph 3. these might not have been the type of product that existed in 1972, but the statute still needs in our submission to be able to deal with them. One then goes on to page 338, please. From paragraph 54 is the discussion paragraph 56, please, my lords. The FTT says the appellant can't simply rely on dictionary definition of confectionery. There's a statutory definition in note 5 which extends the meaning of confectionery to include chocolates, sweets and biscuits drained glacé without any acute or crystallised fruits and any item of sweetened prepared food. And then paragraph 57, the italicised words must be read in the context of the rest of the note, carried to their logical conclusion. They could include cooked, sweet, chili flavoured chicken skewers, which are manifestly not confectionery, so that's where that example comes from. One goes over the page then, please. From paragraphs 59 to 52, the FTT recites the general principles applicable to VAT classification cases, which aren't in dispute. And then at page 343, please, paragraph 68. HMRC must succeed if they're confectionery in the ordinary sense, or if they are sweetened prepared food, which is normally eaten with the fingers in the context of note 5.
Is that the normal way of spelling confectionery, with an A?
Not how I spell it, my lord.
How does the legislation spell it?
With an E.
With an E, yes. Thank you.
I understand it to be an accepted variety, but I use the E myself, generally, for what it's worth.
Of the two alternatives in paragraph 68, the ordinary sense of the word or the tailpiece, which is your case? I mean, which of those are you saying that Mega Marshmallows fall within?
Well, before the FTT was argued that it fell within note 5, and as I understand it, because neither myself nor my learned junior were there, also within the general definition, i.e. on a general approach it's confectionery, or applying note 5 it's confectionery.
So your case is both?
Yeah. But this is not, and I make it plain, that this is not an attack on fact-finding or Edmonton Bairstow or anything of that nature, but fundamentally the submission is that had the First Tier Tribunal looked at note 5 and asked itself whether these were sweets or whether they were within the tailpiece, then it would have compelled the answer that yes, they are. And it looked at confectionery in the round and it came to a different answer. So I can't challenge the one on Edwards and Bairstow, but plainly we submit there was an error as to applying note 5 in that the First Tier Tribunal didn't do it.
So to be clear, for our purposes, the argument on the general definition has gone.
Yes, we're not concerned with the general definition of confection.
Are we concerned with sweets? Because you said that before the FTT, they should have applied note 5, both the tailpiece and sweets. I didn't understand that we were being asked to consider...
No, you're not being asked about sweets because the tribunal was only asked to look at the tailpiece.
So in this court now, for you, it's tailpiece or bust?
Yes. And it's...
Sorry, go on.
Yes, forgive me, my lords. And it's tailpiece and the error of law as to that we submit. So the Upper Tribunals found that the FTT did not apply note 5 because it didn't address the tailpiece and come to a conclusion.
And to be clear, if we accepted your arguments and remitted, what would be remitted would be the application of note 5.
Yes, I couldn't ask for anything more generous than that. unless there was subsequently an application for permission to amend, which would doubtless be resisted in the ordinary way.
What would be remitted is note 5, but I think in fact
Oh, yes, the tail
it's
piece.
just the tail piece, because note 5 includes
Yes,
the word sweets.
Of course.
Yes.
But you're not suggesting that.
No, no.
No, it's just the tail piece.
Just the tail piece.
And in fact, are there findings as to whether it's sweetened and prepared? I mean, that doesn't seem to be capable of much dispute.
Well,
Is it just the eating
I
with
think-
the fingers?
I don't think it was in dispute, and my learned friend will be able to inform the court if I'm wrong. It wasn't in dispute that they're sweetened prepared food.
So it is just the
So
fingers.
the finding of fact that was missing is this using the words of note 5, whether it's usually eaten with the fingers or
Normally
normally eaten with the fingers. And that's the finding that
is missing, you say.
is missing. Well, the FTT said we give no weight to the
How it's
means of
eaten.
eating.
Yes. And the UT accepted that that finding was missing, but said it didn't make any difference.
Yes. And we submit that the UT then in turn got note 5 wrong. There's no justification for upholding. We submit the UT's decision. And so one's not looking at an ordinary value judgment type case where one goes straight to the FTT and says there's been an error. One starts from there being an apparent error on the face of the FTT decision. What is one to then do about that when the Upper Tribunal has looked at the legislative provisions, and we submit ultimately, if the court is minded to accede to our appeal, that remitter would then be on the basis that my Lord Justice Nugee has set out.
So reduced to its simplest, does your case come to this, that if it's eaten with the fingers, it's within note 5, there's no question of any rebuttable presumption, and there needs to be a finding as to whether it's usually eaten with the fingers?
It does.
I mean, is that really, in a nutshell, your
That's
case?
effectively it, albeit that what the Upper Tribunal has gone on to say about the effect of note 5, we submit is of broader application, hence why the Upper Tribunal gave permission to appeal to this court. So
So you'd like us to give general guidance on note 5 generally?
I'd invite you to reject the Upper Tribunal's
Yes.
interpretation of note 5 in favour of the one advanced in this court. Then I'd invite you to agree that the FTT made an error of law in not addressing the tailpiece. Then I'd invite you to consider that there was no justification for the Upper Tribunal upholding that because its own approach to the tailpiece was wrong, and then remit it.
Remit it to decide effectively the question my lord identified. Is it normally eaten with the fingers? And if you win on that, you win, and if you lose on that, you lose. That's your case.
Effectively, subject to what we submit is the absurdity or reality check.
But this is not a case where the absurdity or reality check, on the facts of this case.
That's my submission, my lord. It's just not engaged. There's nothing absurd about treating a Mega Marshmallow as confectionery if it's sweetened, prepared food.
And have I understood it correctly that ordinary sized marshmallows are treated as confectionery for
They are.
VAT purposes, but mini marshmallows, because they're not normally eaten with the fingers but are normally put into hot drinks or sprinkled on cakes, are accepted by your clients not to be vatable.
That they can be accepted not to be vatable because there might be cake toppings or they might be put into hot chocolates in the local Starbucks or whatever it might be.
And you don't eat them with your fingers, you drink them with your coffee.
Yeah.
And just as to your broader point, note 5, I mean, potentially it extends beyond note 5, doesn't it? Because the structure of accepted items and notes runs through Schedule 8.
Yes.
So there's no particular reason for the Upper Tribunal's approach to note 5 not being applicable more generally through Schedule 8.
No, quite, my lord. So the Upper Tribunal has, as we understand it, concluded that because of Section 96(9), the interpretative provision, that is somehow justification for saying the notes are clarificatory only. So that is a prime example of what my lord's identified, which is this going much wider than simply is this product eaten with the fingers.
And even within the food group, mean, we see in Schedule 8, the notes tell you that food includes drink and animal includes bird, fish, crustacean and mollusk.
Yes.
So on the Upper Tribunal's approach, there might yet be argument as to whether a mollusk was an animal. Or
Yes.
For the purposes of the...
Precisely, my lord. So that it is that merely clarificatory or what have you?
Yeah.
So there is it's tempting to think this is a sold just about a giant marshmallow, but the reason that there's been an appeal is because of the wider effect on these provisions if the Upper Tribunal's interpretation of how they operate is found to be right. So, my lords, just to finish on Corte Diletto, what the tribunal did there, which is at page 344, please. Paragraphs 82 and 83 is apply note 5 at 82 and then apply the general approach as well at 83. So they're confectionary on both bases. More recently then, my lords, tab 27 of the second authorities bundle, please. Page 474, that's Dual Fuel Nutrition Limited. That's the intervenor's proceedings in the FTT.
Yes.
I'm sorry, I missed it. What was the result in the Bulls case?
It was confectionery on both.
Both normally eaten with fingers and as a matter of ordinary confectionery. Yes, thank you.
So, my lords, dual fuel, the intervenor's case, this is the products are a protein flapjack and a protein cake or brownie, intended for those about to exercise or having just exercised. Go to page 487, please, of the FTT's decision. Paragraph 93 is the beginning of the section dealing with the approach to be generally taken.
These tribunal decisions show tribunals are often invited not only to look at but taste the product.
They are, my lord.
Yes. Is there a different rule in the Court of Appeal?
There isn't, my lords. But
we're not being asked to find any facts.
I'm not asking you to be a primary fact finder, so I didn't want to offend my lord's dentists with packets of giant marshmallows for your own delectation. But yes, ordinarily the tribunals can end up feeling something like a foie gras goose if there are a number of products to be tried on any given day.
Yeah. It wasn't a serious question.
I hope it wasn't taken as such, my lord. So page 487, the approach to be taken generally is thereafter the multifactorial approach, which isn't in dispute. And then if we go to 495, please, my lord. Paragraph 148, that is the note 5 argument. Two alternative grounds on which the products could be treated as confectionery within accepted item 2, deemed to be confectionery within note 5, or they're confectionery on general principles. If the products fall within note 5, then the products would be deemed to be confectionery, irrespective of whether that would otherwise be the case. If one goes then over, please, to page 500, the FTT sets out its conclusions on note 5. Paragraph 185, please. Definition of confectionery can best be described as an inclusive definition. In doing so, it expands the meaning beyond its normal meaning so as to include those items specifically included in the definition. thereafter at 188, the intervenor's justem generis argument was rejected there by that FTT, but is plainly before my lords on this appeal in the submissions, and I'll deal with that. 189. 188, give me an F. Last sentence. We agree with HMRC that there's no obvious injustice or absurdity in treating the product as being within Note 5 and therefore deemed to be confectionery. That's applying a reality check, if I can use that shorthand, to the product. Thereafter, the tribunal found that the products were confectionery because they answered the final limb of Note 5. And then Obiter found they weren't confectionery on general principles. So that's, my lords have those at 192 to 196. So in our submission, the FTTs in those two cases approached the interpretation and application of Note 5 correctly. The word deemed might have been used. That might not be the correct word, but the answer, as opposed to the label we submit, is the correct approach.
You say it might not be the correct word, but it is a legitimate word on your case, isn't it? You say if you find something that is, whatever it is, sweetened food eaten with the fingers, then it is deemed to be confectionery.
Yeah, it's not used in the technical sense of a statutory hypothesis that creates a world based on a marshmallow being a confectionery, but it has effectively the same effect. So that's why I submitted to my lords that the distinction the Upper Tribunal got into a tangle with between what's technically a deeming provision and what's an inclusive provision that obviously enlarges a defined term is not so great. And the same considerations would apply. Is this just absurd that one has ended up with this result? And one would do that on either approach. So my lord has my submission on that. My lords, there is then the Chancellor in Premier Foods in 2008. That's in the first volume of the authorities at tab 16, please, page 202. Paragraph 18, please. So the Chancellor there, my lords, dealing with an argument in relation to Note 5. And ultimately describing it at the top of page 183 as an enlarging definition. Then, my lords, we have the Upper Tribunal in Morrison's in 2023. You have in the second volume of the authorities, tab 26. I take my lords page 463. Paragraph 94 at G. Again, this Upper Tribunal is not using the phrase deeming as in the technical sense. It's trying to describe in our submission the effect of the provision. G, the Upper Tribunal there says the point of a deeming provision such as Note 5 is that if the specified criteria are met, it saves having to agonise over whether a product is confectionery or not. Then at 467, my lord, the bottom paragraph 116, same analysis, just over the page at the top of 468. If HMRC are correct in their case, it would mean that the products would be deemed to be confectionery and the appellant's appeal would fail in any event. And then 117, note 5 deems products with certain attributes to fall within confectionery. It's the same answer we submit, but just using the term deemed in that loose sense rather than the sense of a statutory hypothesis. The final authority on that then, my Lord, is when that case was remitted back to the FTT last year. My Lords have that at page...
And just to understand, I haven't looked sufficiently to know why it was remitted. It went on appeal and
It was remitted because the FTT had ruled out as relevant whether a product was healthy or not.
I see, yes.
And the Upper Tribunal found that that should be part of the multifactorial assessment. It then went down to the FTT again, who subsequently found that they are confectionery, and that their appeal is then stayed behind these proceedings.
I see.
And they weren't within note 5 because they weren't sweetened. Is that...
Correct. So note 5 was not actually in play on the Morrison's FTT appeal, but the Upper Tribunal was considering how note 5 operated with the word sweetened, because one argument it also considered is whether the Chancellor in Premier Foods had said that sweet is enough, sweetened, sweet is enough to meet sweetened.
Sweetened means you have to add something.
That was the issue.
Yes.
Whether something inherently sweet satisfies sweetened. So note 5 was engaged to that extent, hence the Upper Tribunal making some observations on it. So back to the FTT from the remitted case then, my Lords, that's tab 28. It goes to 510, please. This time with the appropriate accent on Class A. Judge Sinfield, the President of the FTT, we don't think it's entirely accurate to describe Note 5 as a deeming provision. The purpose is to clarify the meaning of confectionery and provide certainty where there might be some doubt. Only operates as a deeming provision insofar as an item which it states is included in the term would not ordinarily fall within confectionery. For example, sweets and chocolates, and then at 17, Judge relies on the same part of Bennion as relied on before my Lords today. And so, to summarise the general approach, my Lords, of those authorities is Note 5 is an enlarging definition. Once something's within it, it's deemed, using that loose word, to be confectionery. It operates to bring items within confectionery that would otherwise not fall within it, unless there's some absurdity as to that result. That, in our submission, had a measure of coherence, certainty and predictability about it to what is a wide statutory definition, and where there may inevitably be difficult cases at the borderline. So I move on to my fifth head, please, submissions, my Lords. That's the instant Upper Tribunal approach. And our general submission on what the Upper Tribunal found is that the entirety of Note 5 is a clarificatory, inclusive definition as opposed to any kind of deeming or other provision that treats the products as if they're something else, or that could enable the word confectionery to be applied to some products to which that word would not ordinarily be applicable. Can I take my Lords to the Upper Tribunal's decision in tab 7 of the core bundle, please? Beginning at page 74, please, which is the analysis of Note 5. beginning at paragraph 39. The Upper Tribunal begins by saying Note 5 isn't a deeming provision 40 because of the language used, so drawing the distinction between the creation of a hypothetical set of affairs and something else. 41, the UT concluding that there's a distinction between provisions that serve to clarify to avoid potential doubt, one aspect of an inclusive definition, and provisions that treat something as if it was something that in reality it's not. And the ultimate conclusion we submit as one goes through is that it is clarificatory only. At 43 on page 75, please. My learned friend, Ms. Brown, submitted to the Upper Tribunal that the purpose behind the amendment in 1988 was to expand the meaning of confectionery. When one tracks that through to 45, the Upper Tribunal says it can't Note 5 can't be a deeming provision because sweets and chocolates are listed and you don't need a legal fiction to create sweets and chocolates as being confectionery. 46, relying heavily on the extrinsic materials. This is the conclusion that it's only a clarificatory inclusive definition. It doesn't enlarge.
I say I'm not quite sure what the significance of that would be, because if you have clarified by saying that something is confectionery, I'm not sure what the difference is from deeming it to be confectionery.
Well, no. The Upper Tribunal did get very hung up on what is a technical deeming provision and not is not. So the label rather than the substance became the difficulty. And we accept it's not creating a statutory hypothesis because one doesn't need to. So in legislation, one may have an occasion where one needs to create a statutory hypothesis from which a variety of consequences may follow. Where one doesn't need that variety, an inclusive definition will do. It's going to have almost the same effect.
I mean, putting it another way, if something specified in Note 5 is not necessarily confectionery, how have you clarified the meaning of confectionery?
Indeed, one hasn't at all. So it's achieved nothing in terms of an inclusive definition. So
what I find odd about this is when one looks at paragraph 43, Ms. Brown was submitting. The purpose behind the amendment was to expand the meaning of confectionery to include modern products, and that's effectively your case as well. It's not clear to me what the ambit of the debate was.
the ambit of the debate before the Upper Tribunal as well appears to have been somewhat ambulatory on a generous reading of it. But what it ended up with was submissions being made that this Note 5 is an inclusive definition and it does expand the meaning, and the Upper Tribunal wanted to grapple with that and came to its conclusion as to the analysis of Note 5. And in doing so, it then used the conclusions it came to on Note 5 effectively in our submission to justify not interfering with the FTC's decision. So one has then over the page at 76, my lord, 47, effectively to the same.
Well, just pausing there, this comes, does it, from Sir Andrew Morritt? An inclusive definition doesn't generally extend the width of the term being enlarged. Now, what does that mean?
What it means, we submit, is as described by Bennion, because if one reads just that sentence, it makes scant sense in our submission, because if something's enlarging the term, it's enlarging the term. Replace width with whatever. It doesn't mean anything. When one looks at what Bennion said, page 555, there's an explanation for that, my lord. So it's in the second authorities bundle, forgive me, tab 31, page 555, at the comment. The explanation there is the term as used in the Act has its natural meaning, which is left undefined, and in addition has the special meaning given to it by the inclusive definition.
I'm not quite sure that I follow how that relates to the previous sentence, which is the bit about affecting the width of the term. But
in my submission, it's meant to be the notion that the statutory term still has an ordinary meaning.
And you've got an add-on.
And you've got an add-on. So the ordinary meaning is left, but one has the statutory enlargement of it. That, in my submission, is the only real way of rationalising what the Chancellor said, or indeed what's said in Bennion. But the Upper Tribunal left it as just with the first sentence, really. More curiously, at 50, then the Upper Tribunal does appear to accept or agree with the Chancellor and Premier Foods that Note 5 is an enlarging definition, having apparently not accepted that it has that effect. So there is difficulty in coherence in interpreting what the ultimate conclusion was, but we do submit that the tribunals determined tailpiece does not have any enlarging function, it's clarificatory only. And that the Upper Tribunal sought to justify by reference to the extrinsic materials, and then at 48, paragraph 48, by reference to section 96.9. So explicitly saying that's consistent with Note 5 providing descriptions of items that are included to avoid doubt as to whether they're confectionery. My lords will know my submission on that, just because it's an interpretation clause, one doesn't read it in that way, and one has the examples of the trio of authorities.
Well, you see, you don't read it in that way, but you're not necessarily unhappy, are you, with the idea that Note 5 provides descriptions of items that are included to avoid doubt?
I'm not unhappy with that as long as one's added to it, and it does enlarge the definition of confectionery, because that's the operation of the tailpiece. So our submission is that when one looks at Note 5, one has clarificatory terms, sweets, chocolates, glacé, cherries, candy, peels, whatever they might be, but the tailpiece is something broader. So if the Upper Tribunal had agreed with that, then I wouldn't be making the submissions to my lords today. So the second element of the Upper Tribunal's decision then, my lords, is the correct approach to construing Note 5 and Item 2, which is also beginning at page 76. And goes on page 79, please. Paragraph 65. In the centre there, there's an agreement with the Morrison's Upper Tribunal, slightly modified. But the point of Note 5 is that it saves time having to agonise over whether a product of that description falls within the meaning of confectionery. Doesn't preclude further fact-finding. It's akin to a rebuttable presumption. And one follows the effects of that through to paragraph 72 over the page, please. What the Upper Tribunal appears to be saying in our submission is that even if you look at something, it answers a description within Note 5, you can undertake a multifactorial assessment and it's no longer confectionery. But that's not trammelled by any particular parameter.
I mean, paragraph 70 is very explicit on that, isn't it?
Yes. I'm grateful. So our submission is the Upper Tribunal's overall approach appears to have been, number one, Note 5 in toto is a clarificatory only inclusive definition. Number two, no part of Note 5 could operate to make something that was not confectionery by the ordinary application of the word into confectionery. And three, Note 5 is not so much a definition as something akin to a rebuttable presumption that can be rebutted by an open-ended multifactorial analysis. So I move, my lords, if I might please, to the sixth head of my submissions. Those are submissions on what we submit as the Upper Tribunal's errors of law. We return to our first overarching submission. Note 5 significantly, deliberately enlarges what is included within the term confectionery for VAT purposes, and the Upper Tribunal erred in finding otherwise. So we submit the conclusion as to the tailpiece being solely clarificatory. Not bringing into the definition products which hitherto had not been is an error. So applying the first proposition on which we rely from what Lord Hodge said in the Project for Registration of Children as British Citizens case, the words which Parliament has chosen to enact are the primary source by which the meaning is ascertained. The words used in the tailpiece are clear and unambiguous. Read normally, we submit they are a very deliberate and significant enlarging of what's included within the term confectionery for the purposes of VATA. On its face, it brings within it products that otherwise would not have fallen within the term. We submit that there's further support from that from the very nature of the tailpiece being an inclusive definition. We rely on Bennion and the trio of authorities cited therein. We rely on the legislative history that I've taken my lords to, particularly the comparison with the immediate predecessor legislation, the abandonment of the prior iustem generis type of drafting, and the mischief identified by the extrinsic aids taken my lords to. So our submission is that the Upper Tribunal erred in concluding that Note 5 was clarificatory only. And we submit that the Upper Tribunal's reasoning as to how it came to that is flawed. Firstly, in treating the entirety of Note 5 as operating in one manner, in that there's no reason why an inclusive definition can't include clarificatory elements and something that is enlarging. And by focusing on the label rather than the function, the deeming provision issue. We submit that the Upper Tribunal's approach to section 96.9 of VATA at paragraph 48, that meant that Schedule 8 is somehow to be interpreted in a clarificatory only way as a non sequitur and an error of law. In that the simple fact of there being an interpretation clause cannot mean that such a clause is clarificatory only. As a matter of principle, it's not, far from it, as per Bennion and Dilworth. The general purpose of such a clause is to enlarge the meaning of the words or phrases occurring in the body of the statute. We submit that the Upper Tribunal's reliance at paragraphs 45, 47 on the notion of sweets and chocolates not being potential candidates for a statutory hypothesis was a further non sequitur. And the obvious reason for sweets and chocolates being included in Note 5 is, as my lords have seen in the 1988 order, they were removed from the item 2, and put into Note 5. That does not, we submit, begin to justify a conclusion that the tailpiece is clarificatory only or had no function of making something confectionery which hitherto had not been. We submit that at paragraph 46, the Upper Tribunal relied too heavily on the background materials, extrinsic aids, that should only have played a secondary role. We submit that the Upper Tribunal erred in using those aids to displace the meaning conveyed by the words of the statute. So reasoning that on the background materials all the words did was clarify and remove uncertainty, and the amendment was limited to ensuring that cereal bars that were not wholly or partly covered in chocolate and other products were captured. And in particular, then reasoning from that, paragraph 47, that the tailpiece did not expand what would normally be included. A clear example in our submission of external aids being wrongly used to displace the meanings conveyed by the words of the statute that are clear and unambiguous. So we submit that the flawed reasoning also suggests that the conclusion is wrong. And we do also submit that its approach amounted to a narrow or strict interpretation of confectionery when there was no requirement for such an interpretation. One could have used that as a sense check for a conclusion, but we submit that that was not done here. Our second submission then, my lords, returning to the overarching one, and how Note 5 best applied when a tribunal's given any product, considering any given product. My lords have our submission that when once Note 5 is engaged, something falls within its clear and unambiguous wording, subject to considerations of absurdity or lack of reality. It's confectionery for the purposes of Note 5, and the Upper Tribunal erred in concluding otherwise. We rely on the general approach to statutory interpretation in Project Blue, absurdity, in Hurstwood, on the realistic view of a transaction. And if one applies those perfectly orthodox principles to this type of issue, one can conclude that something is not confectionery, chili, chicken, skewer, whatever it might be. And these are similar, if not identical, to the limits on the application of true deeming provisions. There's no dispute as to those. If the construction leads to injustice or absurdity, you limit the extent of the statutory fiction. The Upper Tribunal appears to have taken the view that when once you're in the territory of a deeming provision, so paragraph 36, you can't find any further facts. And one that poses the question of how is one then to look at whether the result is an absurd one or going beyond the statutory fiction. We submit that that's not, deeming provision doesn't preclude making findings as to that kind of conclusion. So HMRC does accept that a tribunal can find further facts beyond those needed to ascertain whether a product falls within description in Note 5. That's how one would begin to answer the absurdity or unrealistic question. do submit that it would be wrong for that exercise to be effectively open-ended, untrammelled, either by reading down a statutory definition into something weaker, akin to a rebuttable presumption, or by an open-ended multifactorial assessment that isn't aimed at answering that absurd or unrealistic question. By treating Note 5 as akin to a rebuttable presumption rather than a statutory inclusive definition, and allowing an untrammelled multifactorial assessment to displace it, we submit pays insufficient regard to the definition as enacted, tends towards incoherence, unpredictability and subjectivity. If the court accepts that in amending Note 5, Parliament did intend to set a wide inclusive definition of confectionery, that's what it did. It's not about rebuttable presumptions. It's an error of law to read such a definition as that.
Is rebuttable presumption something the UT said, or is that your characterisation of that?
No, that's what the UT said, my lord.
Where do they say that?
They say that at paragraph 65, my lord, on page 76 of the core bundle. I apologise if I've not taken the court to it already.
Yes.
Paragraph 65, the third line up from the bottom.
Akin to.
It is, in our view, akin to a rebuttable presumption.
Thank you.
So there's no effective qualification we submit on what the Upper Tribunal identified as this potential further multifactorial assessment, save for what it said as there being other relevant factors. So if this was the Upper Tribunal concluding that you can carry out this untrammelled multifactorial assessment amounting to an open-ended value judgment, we submit that that's an error of law, difficult to reconcile with the Upper Tribunal's own agreement that the purpose of Note 5 is to avoid agonising over these products.
Do they follow through that approach when they come to decide whether these Mega Marshmallows fall within the tailpiece?
They don't.
They don't say, do they, that well, on the language they fall within the tailpiece, but that is rebutted by other factors. That's not quite how they.
That's not, as we understand it, the Upper Tribunal concludes that the First Tier was entitled to make these findings, even though it hadn't applied Note 5. Had it done, it would have come to the same conclusion because it was entitled to carry out a broader multifactorial analysis anyway.
Picking up my Lord's point, the Upper Tribunal thinks there's something akin to a rebuttable presumption. That suggests that Note 5 still has some role.
Yeah.
And the First Tier, for whatever reason, doesn't seem to have approached matters on the basis that there was a rebuttable presumption.
No, and it didn't answer Note 5 in its entirety at all in terms of the tailpiece. So it didn't say, I find that this falls within the tailpiece, but we are going to rebut that presumption because of X. There's just not that type of finding in our submission. But we do submit that if one applies the approach for which we argue before my Lords, the FTT carried out the exercise and concluded that this fell within the tailpiece. As my Lord Justice Nugee has identified, we're not in the territory of absurdity. The envisaged uses of the product wouldn't justify a conclusion. If you eat the marshmallow out of the bag for snacking, as the FTT found was one option, it's just eating a marshmallow out of a bag. It's an item of sweetened prepared food eaten with fingers.
So just, this is probably taking out of your course, but following through, 89, the Upper Tribunal says, on the facts of this case, Mega Marshmallows did potentially fall within the descriptions in Note 5. So seemingly you apply something akin to a rebuttable presumption. Did the Upper Tribunal think that that's the right approach?
Yes, the Upper Tribunal thinks that you can take the rebuttable assumption approach, and therefore, even though the FTT hasn't actually answered the statutory question.
But did they attach any significance to whether or not it falls within Note 5? I mean, if rebuttable presumption is to have a meaning, it presumably means you start with an idea that if you're within your Note 5, it's
Yes.
confectionery. But when the Upper Tribunal itself considers the FTT's approach, does it attach any significance to Note 5?
No. But it doesn't go on to make any findings of fact, for example, to say, well, this did meet Note 5. There's just that it potentially did, but that's of no particular import, because one can carry out these other findings of fact that you're entitled to come to, and overall your conclusion may still be permissible. That's the general approach. But if the approach that we argue for is adopted, one doesn't get into absurdity either as product being eaten out of a bag, or a marshmallow being roasted, cooled down and eaten is still a marshmallow. If I put one in a s'more, got a marshmallow between two chocolate biscuits, we submit nothing absurd about that being confectionery. And the Upper Tribunal's justification for this conclusion appears to have been driven by the mini marshmallows cooking chocolate concern, which we submit didn't need to arise.
At paragraph 90
Yes, my lord.
and 91, the Upper Tribunal say that the FTT did make findings regarding eaten with the fingers, and the finding which it records them as having made is that there are different ways of eating it,
Yes.
and the FTT was unable to conclude which method was more usually or more often used. If the burden is on the taxpayer to bring themselves within Note 5, why isn't that good enough for your purposes?
Well,
Perhaps I should ask Mr. Brown that
Yes.
from you, but
yes, my lord.
he's heard the question.
Yes, what we understood is that the FTT has recorded concludes in the circumstances we don't give particular weight to the means of eating, i.e. we're not looking at whether Note 5 is engaged, because if we are, we need to come to a conclusion on whether this is sweet and prepared
But
food.
if they have made that finding that you can't conclude one way or the other, what would we be remitting for?
If they had made the finding that Note 5 was satisfied, for example, then one would be looking at what the Upper Tribunal said about the further multifactorial assessment that you can go on to carry on, which is what it carried on.
Yes, but as we've
if you're-
discussed before, there's no question, it seems, that it is a sweetened product.
Yes,
The issue is whether it's eaten with the fingers
yes,
in order to come within the tailpiece. And if all one can say is that there are different ways of eating it, and unable to conclude which one is more often used, what would we be remitting the case for the FTT to find?
well, the FTT would be entitled to make findings on further evidence, for example, as opposed to just potentially recourse to a burden of proof argument to say, well, this can be eaten either way, and therefore you fail.
They say there'd be further evidence. I mean, if I'm presuming the taxpayer has brought its evidence,
Yes.
it's allowed a second bite at the marshmallow.
Well, there is there is room for that type of application, but one envisages two potential ways of remitter. One would be to a fresh tribunal to consider the matter again, which, bearing in mind the findings of fact, one might see an attraction to, or to say as a matter of law you needed to address note 5 and this is how one approaches it, please now do so based on the facts you've found. So there'd be two potential ways in our submission of dealing with it.
I mean, the original hearing was only a day, so it isn't that if you remitted for new evidence, you'd expect an extended hearing.
No, it's whether either party wanted to take advantage of making any
Yes.
application to do that, bearing in mind the crystallisation of the issue here, and if one's well out of absurdity, knowing that that is the sole thing to be focused on, that the appellant has to prove in terms of the categorisation for that purposes.
I mean, sorry, go on.
No?
I was going to go back to this question about the burden of proof. Suppose it is the case that the FTT has made a finding. I mean, suppose the FTT had said in black and white terms, we have considered whether the Mega Marshmallows are normally eaten with the fingers, and we find on the evidence that it cannot be said that they are normally eaten with the fingers. It cannot be said that they're normally eaten without fingers. Where does the burden of proof lie, and what's the effect?
So the burden of proof as to classification lies on the taxpayer.
On all sub-issues. So,
Yes,
so once you've shown that it's sweetened and prepared food, they have to show that it's not normally eaten with the fingers, is that right?
yes, my lord.
Well, that does, given what the UT say in 91, which is the FTT seemed unable to conclude what method was more usually or more often used to eat, it does raise the point that my lord raised about why is that not a sufficient finding that means that it does fall within the tailpiece, because the taxpayer has failed to discharge the burden of showing that it's not normally eaten with the fingers.
Yes, and it would. There's the two potentials for remitter, or if my lord's satisfied that the burden's just not met and that's what had to be concluded, then that's another answer to the appeal.
That's not really what you're arguing. I mean, you accepted earlier. You were asking for a remitter.
Yes,
because there wasn't a finding on it.
yes, but it would be right as a matter of law that is another way of disposing of the appeal. Is my submission on what my lord's identified. But that is recourse just to a burden of proof argument, effectively. So you didn't prove your case, and therefore that is how one might dispose of it if this court was disposed to allow HMRC's appeal.
Which bit of the FTT decision is the Upper Tribunal referring to when it says that the FTT seemed unable to decide?
As I understand it, they're referring to 42. So as they record at paragraph 90 of the Upper Tribunal decision.
Okay, thank you.
There's no other particular finding that we identify within the FTT's short decision as to that issue.
Thank you very much.
And so, before we went that way, my lords, the submission is that we're not in absurdity here, and even if one is looking at mini marshmallows or cooking chocolate, that's not a necessary diversion in this case, and that wouldn't offend our interpretation of Note 5 and how we submit that the approach should operate. So we do submit that the UT erred in concluding that Note 5 is akin to a rebuttable presumption and then permitting an apparently open-ended and unqualified multifactorial assessment if something does fall within Note 5. My Lord, can I turn to my final head on ground 1, please, submissions on the respondents and intervenors arguments. The respondents' case, we submit, rather mischaracterises that which we make on this appeal, which focuses on Note 5 being an inclusive definition, not technical deeming provision. We don't say that the tribunal can't make findings of fact beyond whether something falls into Note 5. Indeed, we accept that's how a tribunal could, if it needed to, begin to answer the absurd or unrealistic issue. My learned friends say at paragraph 19 of their skeleton that we argue for a construction to restore the tax system to the purchase tax era status quo ante. But we've not made any such argument. Indeed, we do rely on the legislative development from 1963 onwards to show the enlargement of the definition of Note 5. At paragraphs 21 to 22, the respondent appears to agree that Note 5 is an inclusive definition, but argues that it's only clarificatory, saying that the appellant ignores this function, and my lords have had our submissions on that. We dispute that we ignore the clarificatory function. We say that's covered by specific items within Note 5, such as sweets, chocolates, those specific descriptors. But for the defence of the Upper Tribunal's interpretation of Note 5 being clarificatory only, we submit that the respondent's skeleton does not take matters much further. As to the intervenor's submissions, my lords, the intervenor argues also that Note 5 is clarificatory only. One has that from 28 to 30 of the submissions. The main argument of the intervenor is the justem generis argument, and that's the one that I turn to now, if I might, please. That one finds in the core bundle, please, at page 51. Paragraph 11. Paragraph 11 is an iteration, it appears, of what's at 9, but it's a slightly different formula in our submission. So paragraph 9 submits that the tail piece is to be read justem generis by reference to chocolate, sweets and biscuits, etc. But 11 seems to submit that the tail piece has to be read justem generis just with confectionery. But regardless of that inconsistency, we submit that the wording of Note 5 is not that which one ordinarily expects to see of an justem generis type drafting. This is not any similar or any other. Further and fundamentally, if the court does accept our submission that Parliament's intention in adopting the tailpiece to Note 5 was to enlarge the definition of confectionery, that is effectively an answer to the justem generis argument. Because in our submission, it would be wrong as a matter of principle to reach for an interpretive tool like that to seek to undo the legislative intention. Can I take, my lords, in the authorities bundle, second volume, please? Tab 32, page 557. Any and again, my lords, section 23.8 on the exclusion of the justem generis principle. It will be excluded where the contrary intention appears. Express words may be used to make it clear that the residuary words are not to be given a narrow meaning, or this may be implicit, having regard to other relevant interpretative criteria. And the comment, like all other linguistic canons of construction, the principle only applies where the contrary intention does not appear. It's but one of the interpretative criteria that may be applicable. It may be overridden by any indication that the result it produces would not conform to the legislative intention, citing Lord Scarman in Kazi and Kazi. If the legislative purpose of the statute is such that a statutory series should be read in justem generis, so be it, the rule is helpful. But if it's not, the rule is more likely to defeat and to fulfil the purpose of the statute. The rule, like many other rules of statutory interpretation, is a useful servant, but a bad master. And we submit that in the context of Note 5, really the principle has no role to play. There is a further authority looking at the principle in its contractual setting as opposed to its statutory setting, which is in the first bundle of authorities, my lord. Tab 11, page 99. This is Sun Fire Office and Hart, Windward Islands from 1889, Privy Council case. Lord Watson, again, bottom of 99, please. The well-known canon of construction that where a particular enumeration is followed by such words as or other, the latter expression ought, if not enlarged by the context, be limited to matters justem generis with those specially enumerated. Canon is attended with no difficulty except in its application. Whether it applies at all, and if so, what effect should be given to it, must in every case depend upon the precise terms, subject matter and context of the clause under construction. But we submit there's nothing in Note 5 indicating any intention to restrict any item of sweetened prepared food which is normally eaten with the fingers. Quite the opposite. And we submit that applying the principle would defeat the very purpose of an inclusive definition that enlarges the scope of confection.
I mean, if it were to apply, you'd expect it, I would have thought, to apply in relation to the wording of Note 5. But it's very hard to identify a conceivable genus in Note 5. That, I mean,
the only genus one could hazard at is just confectionery. But in terms of identifying a genus to say the principle bites on something, that's all one can identify. But if it's an inclusive definition that enlarges the term, one doesn't then, in our submission, use a justem generis to achieve precisely the opposite, which is the intervenor's effective submission. Not least where one knows from the statutory history that Parliament's deliberately abandoned an justem generis type draft. So the predecessor legislation is the concept of and similar confectionery. And that's replaced by Note 5. So we submit that that is a strong clue to a justem generis not being a helpful or applicable principle to Note 5. My Lord, those are the submissions on ground 1. Ground 2, my submission, we've covered with my Lord's helpful interventions as we've gone along, to the effect that the FTT simply didn't answer the case on Note 5. To do so was an error of law. And the Upper Tribunal's finding that that wasn't material, we submit, was an error. It's enough, we submit, that an error of law might, not would, have made a difference to the decision. De Gorse, there's no dispute as to that proposition applying. So where the FTT has erred in its approach by not taking that step at all of concluding on Note 5, we submit that that must have been, by definition, materially erroneous. Had the error not been made, the FTT's decision might have been different, and that's why we invite the court, if it's minded to allow our appeal, to consider remitting it to the FTT, again, save for alternative routes that we have not sought to press, but which my lords have identified. My lord, might I turn my back?
Yeah, please.
I'm grateful, my lords, that those are our submissions, unless there's anything else.
Do you have,
Sorry,
can you? I'm sure you have explained this. Can you explain again why mini marshmallows are not within Note 5? Is it because they're not normally eaten with fingers, or because they're not sweet? Or what?
There's a variety of ways in which one can approach mini marshmallows we submit. So, firstly, if one was looking at the tail piece, they're not normally eaten with the fingers. They'd be put onto a cake or put in one's hot chocolate to drink.
Why are they not sweet?
They either could be sweet, in which case one would then apply well, is this an absurd outcome? Or one would say they're not sweet because the legislation is aiming at these types of sweet treats that one eats as confectionery in the ordinary way, and
Something you eat out of the packet.
you eat it out of the packet with your fingers. It's sweet. I mean, the ordinary way of approaching confectionery on a multifactorial assessment, one can say these products are being intended to put on a cake or what have you. They're not the type of sweet snack this legislation is aiming at. So there's a variety of ways in which one can approach mini marshmallows. Either they're just not sweets at all, or if they are sweet, this is outside the demonstrable purpose of the legislation, and so you apply the absurdity check, and they're not ordinarily eaten with the fingers, so they're not caught by the tailpiece.
I mean, I suppose it could conceivably be significant where they're sold, are they, or how they're marketed. Are they marketed as cooking ingredients, or are they?
Yes. So one would have those. These cases near the borderline, one will always have those focuses on particular aspects of how things are marketed, but there is a way through to come to the result.
Or I suppose that if one is being strict, they are sweets, but HMRC is being uncharacteristically generous.
It could be that, my lord, no one wants untaxation by concession where that can be avoided in terms of certainty, but that certainly one could say uncharacteristically generous.
And the same analysis with cooking chocolate. Cooking chocolate's not normally eaten with the fingers, so it doesn't come within the tailpiece, unlike bars of
Yes.
eating chocolate. I mean, the reality is they often look quite similar, but you accept there is in principle a difference between chocolate sold for eating and chocolate sold for cooking.
Yes. So cooking chocolate is generally of a different strength as we understand it. It's used for icing the cake or whatever it's used for. It's not being used in the way of a sweet snack like a Mars bar or whatever one's archetypal chocolate bar might be.
I did look in the supermarket over the weekend, and you do find 70% chocolate on sale in the confectionery section at one price, and 70% chocolate on sale in the cooking ingredients at a lower price, which is presumably because of the VAT impact.
One presumes so. I've not carried out the same. I did look for some marshmallows, my lord, but not for those. But whilst there will be those borderline cases, we submit that our approach provides a more principled route through, with lines for a tribunal who's got to wrestle with cases near the borderline to come to an answer, as opposed to a finger in the air, multifactorial assessment without regard to principle.
Yes. Well, I think it follows what you've said, that if the evidence was that Mega Marshmallows were sold only as an ingredient, only as a cooking ingredient, they wouldn't be taxable. They wouldn't be taxable.
Yes, those types of products, if one has things that are sold specifically for use as ingredients, then that's an accepted outcome of the analysis, that they don't fall within it. Hence cooking chocolate, hence mini marshmallows.
But I thought I heard you say, or I may have misheard this, that even if Mega Marshmallows were generally sold to be put into s'mores, they could still be taxable.
Yes. So our submission is, if you took 2 Mars bars and put a Whisper between them, Whisper bar, that would still be confectionery. You've just put confectionery between two sandwiches. So if you take chocolate biscuits and put a marshmallow between them, that doesn't deprive it of being confectionery.
I thought a s'more, reading about it, I'd never heard of it before, was marshmallow plus chocolate plus digestive biscuits. And the digestive biscuits would not be taxable, would they?
Digestives on their own, but I'd understood s'mores from my limited experience to normally be by taking the 2 chocolate biscuits to avoid having another piece and then inverting them with the marshmallow between. That's how my sons had them at Beavers or whatever. In terms of trying to give evidence, my own practical experience of the classic American treat, that's how they've been done as I've seen them. That would be one piece of confectionery between 2 others.
Okay, thank you very much. Thank you.
On that note, my lords, I think those are our submissions.
Thank you very much. Mr. Brown.
Thank you, my lords. I have to say I'm still a little confused over the Commissioner's case over what a deeming provision is or isn't, or what the effects of it are. The case before the Upper Tribunal was that it was a deeming provision. See that from the decision itself. And then in that case, after the closing submissions were made, perhaps more accurately to put during closing submissions, the Commissioners brought to the Upper Tribunal's attention that there was the dual fuel case was on foot and had just been heard, and therefore written submissions were asked for in respect of what Note 5 actually meant. So if we go back to the First Tier decision, just bear with me for a second. The decision of First Tier Tribunal, which was aware of Note 5, because it mentioned it at paragraph 10, so that's page 155 of the core book. Final sentence of paragraph 10, having said that, with a reference to Chancellor and Premier Foods, a reference to confectionery being normally eaten with the fingers appears to have subsequently found its way into Note 5, Group 1. So how did the First Tier Tribunal approach the question at all? Goes through findings of fact. I'll come back onto those, or submissions rather, come back onto that a little while. So if I can invite your lordships to go forward to page 160, that's the internal page 7 of the decision, paragraph 46. The issue we must decide is whether the term confectionery includes an item which is intended to be subject to another cooking process before being eaten, and to some extent intended to be used as an ingredient in making another product. Paragraph 47, my submission. look at the typical consumer, the ordinary person in the street, and whether or not it's sold in a confectionery aisle of a supermarket. And then the final sentence, that is the case in relation to the product, whether it is enjoyed by consumers having been roasted, or whether roasted mallow is then used as an ingredient in making a s'more. And paragraph 49 is where the tribunal sets out its decision. On balance, we accept the product does not fall to be described as confectionery. The fact that it is sold and purchased as a product specifically for roasting, the marketing on the packaging of the product, which confirms the purpose, I beg your pardon, size of the product, which makes it particularly suitable for roasting, and the fact that it is positioned in the supermarket aisles in the barbecue section during the summer months when most sales are made. So those are the facts that the First Tier Tribunal decided were important, and that was the question it felt it needed to answer, whether doing something to the marshmallow, i.e. roasting it, prevented it then becoming sold as confectionery. Go to then, just following on from that, the upper tier's decision, page 71 of the core bundle. Internal page 6, paragraph 25. Ms Brown submitted that Note 5 is a deeming provision. An item falls within the description of Note 5. It is automatically within the ambit of Item 2, and that is the end of the matter. The item is deemed to be confectionery. It is only if an item does not fall within the description of Note 5 that a multifactorial assessment is required to determine whether it falls within accepted Item 2. Paragraph 27. In the written submissions on this issue, HMRC's position appears to have altered somewhat, and then sets out Benyon. Then at the bottom of page 72, paragraph 28, final sentence. She, Ms Brown, asserted that it's appropriate also to describe an inclusive definition as a type of deeming provision. The label is irrelevant as they have the same legal effect. Any item that falls within a description of Note 5 is automatically confectionery, without caveat or override. And there is slight confusion on the respondent's part. Are the commissioners saying that, and I think they have said it, it is an effective a deeming provision, even if it is not in law a deeming provision?
When you say not in law, what in law is a deeming provision? I mean, it isn't a term you find in any statute.
No, sorry, I withdraw in law. It's either, if it's a deeming provision where the effects are that is the end of the matter, and therefore there can be no further fact-finding tribunal to find facts or make its decision, then that in itself is completely unworkable. The commissioners talk about cases at the margins. Well, what exactly does that mean for a tribunal where a product is in question? How does that tribunal arrive, for example, as to what normally means without some inquiry?
I have to say, in my limited experience of these things, the inquiry doesn't seem any more difficult than those I've encountered before as to whether Lucozade Sport is a beverage or whatever.
Yes.
And as to whether food used for working dogs is pet food. I mean, that's the sort of thing that tribunals have to deal with,
Absolutely.
HMRC have to deal with.
Absolutely.
So why is this different? Why is it more difficult to work out whether food is sweetened, prepared food that is normally eaten with fingers?
It isn't difficult, my lord. One has to make inquiries as to what normally means, for example. In respect of different products, it may mean different things. Who knows? there has to be a fact-finding inquiry by the tribunal.
As to
Well,
whether
that's-
it's normally or not.
Yeah, exactly. And that's the point.
But that's part of the inquiry before you get to the decision whether it's in Note 5.
Of course it is.
Whereas Mr. Watkinson's submission is that once you have determined that it is within Note 5, because you have reached a conclusion about what normally means and applied it to the facts,
Yes.
then that's the end of the matter.
I can't disagree. I think perhaps there's a hang-up on what is a deeming provision or has been in terms of the Upper Tribunal. I mean, I can take you to Morrison's, you've been taken to it. It is the only tribunal decision that mentions deeming provision. And yes, it does mention deeming throughout. But of course, when it was sent back or remitted back to the Upper Tribunal, it was remitted back to the tribunal with the ability to find further facts. But if it's a true deeming provision, you wouldn't do that.
I mean, as you say, there's a danger of getting hung up on terminology.
Indeed.
The question is, if you find something that is, whatever it is, a sweet and prepared food that is normally eaten with fingers,
Yes.
is that, for the purposes of the legislation, confectionery, subject only to absurdity, without needing to think any further about what confectionery might mean? And as I understand it, you say that's not the case, and the Upper Tribunal said that's not the case, and the Revenue say it is the case.
Yeah.
Now, if the Revenue are right, in some sense you can say if you find something within Note 5, it is deemed to be confectionery. But any learning there might be as to what is a deeming provision or an interpretive provision doesn't seem to matter really.
I agree with that. Yes, I agree with that. Provided that there is, or each party has the opportunity to put forward facts before the tribunal, on which the tribunal, and they always do, can make a decision as to whether an item or a product falls within Note 5.
But it's a different decision to be made, isn't it, on your case as compared with the Revenue's case. On the Revenue's case, the decision to be made, subject only to absurdity, is it a sweet and prepared food normally eaten with the fingers?
Yes.
And that's it, really. And you say that's wrong.
No, I don't necessarily say that it's wrong, provided that it's the narrow definition of what the commissioners have not or hadn't previously said, was that there would be this multifactorial assessment to decide whether it was included in normally eaten with the fingers.
Doesn't the multifactorial assessment come in at the earlier stage, which is whether it falls within the normal meaning of confectionery?
Yes.
A point on which Mr.
Yes.
Watkinson accepts that the Revenue lost
Yes,
and can't rely on that any further.
correct.
Um,
Correct, my lord.
But whether it is relevant to the tailpiece
Yeah.
is another matter. For example, the tailpiece does not say anything about how the product is marketed.
No, it does not.
So one would think, therefore, that for tailpiece purposes, marketing doesn't matter unless, once you've decided it is within the tailpiece, you've still got another
Yes.
multifactorial assessment to do.
Yes, indeed, and I think that's the point in terms of clearly marketing has featured quite heavily in previous authorities as to whether something is confectionery or not, and that clearly was the case in the First Tier Tribunal. In this case, there
So-
wasn't a question
sorry.
initially. Sorry, Mark.
No, complete what you say.
It wasn't a question whether something was normally eaten with the fingers. Hence why the First Tier Tribunal said, well, we don't give it any weight because we're not interested in whether somebody's eating it with the fingers or not. What we are interested in, was it roasted beforehand? Was it marketed as being something to be roasted? And that then changed it from being something that might have been confectionery into something that wasn't.
So can I be clear what your case is? Forget for the moment about all the tribunal proceedings there have been.
Yeah.
When you take a product as to which there is dispute, and HMRC say, well, it's within the tailpiece to Note 5,
Yes.
is it relevant to ask about marketing?
I think if the, I think it is, because it still comes back to Note 5 and the schedule relate back to Section 30, subsection 2 of the Value Added Tax Act, which talks about a description of the goods or services. So marketing, in my submission, goes towards description of a product.
So can I just be clear? If you find a product that is in fact a sweetened prepared food which is normally eaten with the fingers,
Yes.
how does your case work? I mean, are you supporting the Upper Tribunal's view that there's a rebuttable presumption that it's confectionery?
I do support that, because the Upper Tribunal don't say it was a rebuttable presumption. It said it's akin to rebuttable presumption. And therefore, the burden of proof, as you've already heard, your lordships have heard, is on the taxpayer to prove. There's no question about that. And therefore, in my submission, the Upper Tribunal were trying to say, well, and sensibly, if there is a finding, then it's normal practical, in its normal practical sense, it's for the appellant in the case to try, the burden of proof being on it, to displace that finding.
And that's probably going to be a convenient moment.
Thank you.
So we'll resume at 2 o'clock.
Thank you.
Court rise at table.